Hi, Bill Henshaw here again, your walking constitution out here in San Francisco. And this is a follow up in an important area I've been dealing with landlord tenant cases and summary ex parte evictions. And the important parts here are what you need to know in the situation as a quote unquote tenant is that they can't prove any of it, especially a corporate landlord who does not have standing in any judicial court. Note that you and I, as lawful de jure jus sanguinis state citizens, or inhabitants of a state or inhabitants of a territory, have the right to trial by jury according to the course of the common law and the writ of habeas corpus, aka the Great Writ of Liberty, since Magna Carta in 1215, and we have not made any voluntary, knowing, and intelligent waiver of not only these rights, but any rights secured by all 6 articles of the Constitution. Yeah, and this is a major big deal because even with these big time corporate landlords, and I've got one currently on the hook in Illinois, I'll keep you updated on that. That we're going after in a quasi class action setting for all like situated victims. And that's what can happen here. And that's what even these fat cat corporations can't have come to light. As we get one case on the record decided on the issues I advocate, particularly by the U.S. Supreme Court, which has sounded more and more like me over the course of the last 2 terms, and they're set to come back into session on Monday, on October 3rd. If that keeps on, we're in great shape here because they've been doing things that haven't been seen in 90 years, acting as a judicial court. I've discussed that on other videos. I'll probably go over it again on a future video. But the big deal here is that these fat cat corporate landlords and their goddamn attorneys know what's going on there. I mean, they see it. There's been an all-out assault on the administrative uh, state that you're subjected to in the Supreme Court and in the Fifth Circuit Court of Appeals in particular. And they're saying it in no uncertain terms. Enough is enough. And that means that we get one decision against them, and that's going to give rise to claims from tenants all the way from Portland, Oregon to Portland, Maine. Same issues, same setting. Going to put the bastards out of business, and that's exactly where they belong. And I'm here to help you with it. For more information, send me an email, youwinnincourt@gmail.com, and I'll send you information on what I do and how I do it. You're going to love all of it, and it's going to make really good sense. That's the important part. And it would to a jury that we're never going to see. That would be my job to explain it to a jury that's full of what the system sees as incompetent, if not ignorant, individuals. And they're right, because there's no meaningful substantive protocols in the mandatory public education system to study the Constitution, history, and laws of the United States. Weren't there 50 odd years ago when I was in school, and when, in my case, right outside of Washington, D.C., better overall education, to be sure, was handled by the local county school board then, not by the state like they all do now, quote unquote state. But the information we got on the subject matters I've since learned was absolutely zero. They don't want you to know the truth because that's going to put them out of business, and it may do worse than that. And that's exactly where the bastards belong. So send me an email for information, youwinnincourt@gmail.com. Among other things you're going to learn is that the last president in office was March 4th, 1869, who happened to be our best president, Andrew Johnson, and that Congress has had nothing remotely related to a quorum to do business in either house for over 100 years, and it gets a lot better than that, too, meaning all the laws seemingly on the records are also null and void, nunc pro tunc ab initio. That's the power we have, and we're supposed to have it. And that's what I felt in my South Carolina case I've discussed on earlier videos, when I got hauled across the country for 2 months on a BS practicing law without a license charge. And they read the charge on my first appearance there. And I'm manacled hand and foot in a red jail suit, which I found out later they gave to people accused of murder. And I laughed. And I said, the problem with that is I don't practice it. I get it right the first time. They then went on and said, oh, we have to be sure you're competent to represent yourself. If I could have thrown up my hands, I would have. I said, oh, Barthetta, Beretta v. California, 422 U.S. 806. The problem with that is the Supreme Court decided in Barron v. Baltimore, 7 Peters, 243, 1828, the Bill of Rights doesn't apply to the states. Stunned the courtroom into silence in 60 seconds, from which they never recovered. And that's $1 million video if I had it, because the looks on their faces. And there I am, alone on my own. They're the ones in trouble with the law, and everybody knew it. That'll be true in a landlord-tenant setting, too. I'll do the same damn thing if it's ever necessary for me to make even a Zoom appearance, and it probably won't be. I mean, the issues and the support we have, particularly from the U.S. Supreme Court, that's what they're going to see. That's from their bosses deciding all these quote-unquote vintage cases, but they're still there because we can prove not only the 14th Amendment doesn't exist, it never did. To find out more, send me an email, youwinnincourt@gmail.com. Meanwhile, subscribe, like the videos, get the word out. The sooner we get these bastards off our backs, the quicker we get back to the government that we should have and get on with the good life that the framers had planned for us. And that's what all of us want to do. We want to do it for ourselves, our children, and our posterity. Thank you.